Some time has now passed since Brexit and the first hustle and bustle surrounding the UK's exit from the EU has subsided. It's time to take another look at the current situation regarding intellectual property rights and to sound out any further need for action. As a reminder, until the end of the transition period on December 31st, Union law continued to apply to intellectual property rights, in particular to trademarks and community designs protected across the Union, and that also in the United Kingdom then. Since the beginning of 2021, the corresponding rights have lost their protection there. National clones emerged. Even 5 years after the Brexit referendum, the aftermath of the exit is not over yet. The late registration deadline that ends on September 30th must be observed. Clones have emerged in the UK in favor of EUTM holders or EU Extended International Registrations. This was done automatically by the UK Intellectual Property Office, the UK IPO, without reapplying or incurring additional fees. The clones received new register numbers, which are basically composed of the old register numbers and national prefixes. Owners of property rights recognize the clones of earlier Union trademarks by the number combination 009 and, in the case of international registrations, by the number sequence 008 at the beginning. The most important property of the clones is that the priority date and the date of the end of protection correspond to that of the corresponding EU property right. Particular caution is required here, however, with the European parts of the international registration of trademarks. The date of the end of protection is to be calculated based on the date of extension to the Union and not from the original registration of the international registration. The after effects of the resignation are particularly evident in the late registration period in the UK, which runs until September 30th, as I said. Union trademarks and European parts of international registrations that were still in the application stage by the end of the transition period were not converted into UK trademarks or not cloned as such. Here, however, there is the possibility of applying for a UK trademark up to the aforementioned point in time while maintaining Union priority, for which a fee is incurred. A separate registration process has to be initiated in the UK then. In the meantime, right holders will have to decide whether to claim trademark protection in the EU and keep the appropriate seniority. The same essentially applies to community designs. With regard to the right-preserving use of a trademark, the withdrawal agreement stipulates that the cloned trademark must not be counted that it had not been used in the UK before the end of the transition period. In this respect, any use made up to December 31st in an EU member state is sufficient for legal use. Conversely, use in the UK from January 1st is no longer valid in the EU. Existing license agreements and delimitation agreements should also be taken into account. It's necessary to interpret whether these will continue to apply to the UK in individual cases, especially if the agreements claim to be valid for the European Union. This must be checked on a case-by-case basis. Finally, it should be noted that representatives who are not based in the UK can still represent trademarks before the UK IPO until at least December 31st in 2023. This also shows that even after the end of the transition period and a total of 5 years after the referendum, Brexit is still having an impact and current developments must continue to be kept in view. And there are so many other fields where that applies. If you've seen my videos, you will know what I'm talking about. I'll see you in my next video. Bis gleich.